Tomorrow.
not taken.
Admission number 1, Sri K.V. Arvind.
One 52. Whoa. Yeah. This is item 1. And what about this thing? 2, 3, and 4?
2, 3, 4 do not have everything out of the same one. 3 questions.
Mr. K.V. Arvind, the counsel for the revenue, the counsel for the revenue submits that similar substantial questions of law which arise for consideration in ITA number 147/2021 has been 22 has already been admitted by this court. The proposed submission. The appeal is admitted for hearing on following substantial questions of law 1 to 7, which is notice list along with ITA 147/2021. What about this?
Already admitted
127 or 22. This along with ITA 127/2020. Yes.
Preliminary number 5, Sri Pradyumna Hejip, Government Advocate.
Your Lordship, I appear for this, Your Lordship.
Yes, please.
Manpower. Lordship, serial number 5, Vision Manpower. I appear for.
Yes. No, you should nowadays you should talk of women power instead of manpower, right? Okay. All right. Yes. Yes.
Lordship, may I make my submissions?
Mister, can you tell us why it has come up before us?
Yes, Your Lordship. I will take not more than 5 minutes, Your Lordship.
No, not 5 minutes. I mean, why
Yes,
it has come before division bench? I mean, that should, what
you
he says, Mr. Jeevan says that similar rate petitions are pending before a single judge, and he is curious to know why it has come before division bench.
Your Lordship, I do understand.
But telling some virus or something.
Yes, Your Lordship. No, Your Lordship, what has happened in cases filed, writ petition filed before the honorable single member bench, where the show cause notice itself were stayed, Your Lordship. A prayer was made by different petitioners to stay the show cause notice and the adjudication proceedings. In my case, Your Lordship, I participated in the adjudication proceedings involving all similar matters, that is solid waste disposal for BBMP. I participated in the adjudication process under an earnest hope that the adjudicating authority would consider my submissions. What has happened, Your Lordship, has overlooked a government circular and has
That's all right.
Yes, Your Lordship.
That's all right. I mean, basically, you seek a writ of mandamus directing the authority to decide your appeal without insisting on a pre-deposit of
Exactly,
7.5% of the
exactly,
service
Lord.
tax.
Exactly,
So tell us
Lordship.
why it should not go before single judge, how it has come before us. That's
It
the
can go,
question.
Lordship. It can go,
That's
Lordship, before single.
the
Yes,
registry.
yes,
uh,
Lordship.
uh, So you said, and now let the registry verify what's there. It will come up next week. Don't worry. Yes. Learned council. We don't know. You said office to in this writ petition, comma, the petitioner seeks right of mandamus directing the authority to hear the appeal on merits without insisting for free deposit of 7.5% of service tax. Office to uh, office to verify and to list the matter before appropriate bench in the next week.
Oblige, Lordship.
Private number 6, Sri Chandrakant Gowda.
My lord, I appear for the petition. May I request for 10 days time, my lord. I shall file the second set and
10 days time. 2 weeks. 2 weeks.
much of it.
Number 7, Sri Raghavendra B. Hanje.
I'm for the appellant in this case, Your Lordship. I mean, in fact, what has happened, Your Lordship, after filing up the appeal, the client has not turned back. So we are not able to, as a last chance, I pray for 2 weeks. I mean, if possible, we will do it. Otherwise, it can be dismissed.
2 weeks failing which appeal shall stand with the petition. Appeal shall stand dismissed without reference to them.
Obliger.
Number 8, Industry Esra, Government Advocate.
Right. Write his name heard on
We were not dismissed. And that day,
not this.
except this other matters were dismissed.
Your case to see, we had given you special treatment. He is telling us all other cases we are dismissed except your case. So now we will dismiss your application for recall today. What was the order of the exit? What was the order of the exit? Then last is
Last time it was adjournment, daily adjournment. Process, they have to pay.
process fee you have to pay. Undertake to comply with office objections within a week. Seek leave of this court to withdraw IA 1 of 22. Dismissed as withdrawn. Office is directed to reflect. What's your name? You have given. Office directed to reflect the name of as counsel for the action.
9,
Serial numbers. Yeah, I'm as soon as I'm also not sure they're not admitting me, but I'm asked on like several WhatsApp groups to find out. Yeah, that's all. I've asked on those. I'm just waiting for a response from that. But I'll keep you updated like as soon as
Something else.
Some other conversation.
number 9, Mr. Deepak.
And for the appeal to stay. And for the appeal 2 weeks.
Number 10, Sri Raghuram Kadambi.
3 days. Week time. And ask him, what's your name? And please tell what's your name. Current council, week time. 11 also, week time.
Number 12, Sri Muniappa, Government Advocate.
My lord, for the respondent, my lord. My lord, I have filed my status report, my lord. Till date, we have filed 4 status reports, my lord. The husband has filed the petition that the wife is missing, my lord. All the efforts have been made by the respondent police to trace the missing wife, but whereabouts were not known, my lord. Since 2019 till date, we have filed 4 affidavits, my lord, status reports. Paper publication has been issued, lookout notice has been issued, my lord. And we have also collected UDR registers from various.
Wait, the counsel for petitioner is not there. We will pass it.
My lord, he is there, my lord. He is on the. We see.
Yes.
Sri Muniappa.
Okay. Can you see him?
Yes, my lord. I can see him. He is there. I think he has
So
muted
please
his
tell
mic.
Please,
Sir, unmute madkoli.
please tell him to address the court.
I appear for the petitioner, my lord.
Please.
Yes, Mr. Have you heard what Mr. SPP has said?
I heard, my lord. I have also received the report. I also received the report.
No, on the lighter side, Mr. Mudiappa, you should feel happy, right? Any other person in your position would have felt happy on the lighter side. I mean, of course. But why don't you see? This appears to be a matrimonial sort of a dispute. Your wife has left the matrimonial home. If you want to live with her, file a petition under Section 9. Otherwise, seek divorce under 13. Whatever. This habeas corpus may not be. They have done their best. He said that everything, your wife must be somewhere.
I will advise my client to start some
Ah,
other remedy.
Mr. Muniappa, learned counsel for the petitioner, learned SPP. This petition has been filed. Seeking a rate of EPS corpus for production of the corpus, production of Ms. Janvi. Production of Mrs. Janvi. Janvi. The petitioner claims that Mrs. Janvi is his wife. So, stop. The respondents have filed 4 status reports in which they have stated that the investigation has been carried out and all possible steps to trace the missing person have been taken. However, despite best efforts, the respondents are unable to trace the missing person. In view of offensive stands taken by respondents in the 4 status reports filed before this court, learned counsel for the petitioner submits that he be granted the liberty to take reports to such remedy as may be available to him in law. In view of offensive submission, the petition is disposed of in terms of liberty as great cause.
Number 13, the Veeranajit Sigiri, Government Advocate, Srimati S.R. Anuradha, Srimati Swati Ashok.
Your Lordship, for the respondent number 2, Your Lordship.
Yes, madam.
I will rectify the office objection, Your Lordship. Request for a day's accommodation, Your Lordship.
What's your name?
Swati Ashok, Your Lordship.
Sorry, counsel undertakes to comply with office objection within 3 days. List in the next week. Yes.
14,
Please, Your Lordship.
Pinakanji,
I don't say next week. Yes, after one.
Sri Rabinathanji,
Yes. None for the happening 2 weeks.
number 15, Sri Harish H.V.
Yes.
Jana Nayak,
3 days time. Paper in 3 days time to comply with office. Hey, what you can please, war officer, you take notice what. Mark is present, learned. Additional government, you are additional government advocate. Take notice on behalf of respondent number 3. Office is directed to reflect his name. Office objection we know. 4, 5, and 6. Please, sir.
number 16, Sri Siddharth Babura, Sri J.D. Kashinath, Government Advocate, Sri T. Sheshagiri Rao,
They have to pay process fee. So we have granted 2 weeks time. Yes.
number 17, Sri S. Balakrishnan,
Appearing for the petitioner, my lord. My lord, the petition stands infructuous, so we are withdrawing the petition, my lord.
Leave of this court. What's your name?
Subhash, my lord, Subhash.
Right, counsel for the petitioner seeks leave of this court to withdraw the on the ground that the
My lord.
has been
My lord, both 17 and 18, my lord.
The appropriate statement is taken on record. Accordingly, the petition is dismissed as infructuous.
For the respondent, my lord.
Fine. You are which is all right. Learned SPP. In 18, he is appearing for respondent.
Please, my lord. For all the respondents.
Appearing through video conferencing, you have not come to court.
My lord, I had an ankle twist, my lord, yesterday. A small injury on my leg, hence appearing.
Yes.
number 19, Sri Srimati Hema Mahadevi,
My lords, I appear for the petitioners in this matter.
Thanks.
My lords, the office objections were complied with by my colleague. My lords, I will verify again what objections have been raised. I request for a
How
week's
much
time.
time?
1 week's time, my lords. Much obliged.
20. The H.S. Srinivasan.
My lord, I appear for the petitioner. My lord, I have complied with the office objections, and it is in the website also. It is showing that I have complied, my lord. Some reason it is there.
Matter pertains to division means second set to be filed.
You have to file second set. One more set.
We have already filed, my lord. It is showing that it is complied with.
It is complied with. The record is not there. Will you file an extra additional set?
Yes, very well. My lord, one more aspect, my lord. There is a cross petition which has been filed in respect of the same award. And in that, my lord, the court has already passed an order to club it along with this matter, my lord, because the award is the same. That is 15173 of 2020, my lord. 15173/2020. An order has already been passed in that to club it along with this matter, my lord.
All right.
It may be posted.
Next week.
Yes, my lord. It was supposed to come on 7th. It has not come, my lord.
The AJ Srinivasan Learned Counsel for the petitioner undertakes to file another extra set of this petition along with the registers by tomorrow.
Yes, my lord.
By tomorrow or within 3 days? By
yes,
tomorrow.
By tomorrow.
Just along with WP number so and so, right? For analogous hearing on the next week.
Very well.
Next week.
Number 21.
3 weeks. All right. 5 3 weeks.
Number 22. The Sandesh Shetty. The P.B. Raju.
My lord, I am for appellant, my lord. My lord, my lord, claimant has sustained paraplegia. My lord, was pleased to pass orders on 19/4/21, my lord. And in respect of the loss of future income, the award was enhanced. And kindly peruse page 5, paragraph 7 of the judgment, my lord.
The correction which you want.
5, paragraph 7, my last line I may be permitted to read, my lord. The report submitted by Wenlock District Hospital, Mangalore, discloses that the appellant suffers from the permanent disability to the extent of 75%. The aforesaid report has been admitted by both the parties. Therefore, we hold that appellant has suffered 75% of permanent disability on account of the injuries sustained in the above accident.
There's a small typographical error that needs to be corrected.
Typographical error.
That's what he is telling us. That's what we are requesting.
That's all. That's all.
My lord, 1 lakh.
What is the percentage?
Last line, madam. Last line in that paragraph, madam.
It should read 14 lakhs, 11,120. It reads 1,41,000.
1,41,120.
How much? 14 lakhs?
14 lakhs, 11,120,
madam.
So that's what you should tell us, right?
That is all, my lord. There's a typo error.
Thank you. Yes.
That is the only typographical error, madam.
Heard on IA number 1 of 21, an application for correction of judgment. Judgment dated 19/4/2021, passed by this court in MFA number 5198/2015. After hearing learned counsel for the parties in the last
loss of future income
at page 6 in the last but one line of para 7, comma instead of the figure mentioned therein as 1,41,120 shall be read as 14,11,120.
Yes, 120. Applies, direct
one.
In 120, you are saying 200.
14,11,200. I have calculated. 14,11,200.
Mr. Raju, he says.
I have corrected it and I have sent it to my company, my lord.
No. We wanted to inform that Our court officer informs that the amount is 14,41,000.
14,11,000.
11,200 instead of 120. We don't know.
Very well.
It says here.
Please,
Right?
Lord. It can be corrected.
200. This order shall be read.
Applies.
Yes, this order shall be read in conjunction with the judgment dated so and so 19th April 21 in MFA 5198 according the IS 1 of 21 is disposed of.
Applies. Grateful.
23. Sri Nishant SK.
I am appearing for the petitioner's counsel.
Objection. Yes.
I am appearing for the petitioner's counsel.
Oh. Mr. Patil, shall we hear you either tomorrow or day after? Because you know. Yes, Mr. C.
I am appearing for the petitioner.
What we are trying to tell you is that we have made a suggestion to Mr. Patil that we will hear this case tomorrow or day after. He says tomorrow. So shall we? Because we'll be sitting till 4:45, 5 o'clock, no problem. So we will be able to hear, right? Because it has to be decided.
Yeah. 2:30 minutes.
Whatever. I mean, whenever it comes, we can't say what time it will be. But today the bench is till 1:30. Then again,
please,
so,
as you please.
So tomorrow, Mr. Patil, yes, mark the presence list tomorrow. When have you filed this object? Day before. Learned counsel for Mr. Ajay Kumar Patil, learned counsel for respondent 14 to 18 submits that he has filed objections. Objections to IA for amendment. Then on 21st February 2022, as well as has also filed a memo. The aforesaid objections and the memo be placed for consideration on the next date of hearing, this tomorrow.
Including application, or application is not put up.
Of course. Obviously, it's there.
Please.
So it will be virtually finally hearing all of you. That's
Please.
Fine.
Please.
What memo? So memo filed by petitioner be also placed for this thing for consideration, right? 15. Fine. Yeah.
24. Udita Ramesh. CH Devendra Babu.
Yes, madam.
Mahabaleshwar. Vip Prakash.
I appear for respondent number 2 in this matter, my lords.
I'm appearing for respondent number 3 and 4.
Oh, yes. Why, Mr. You should pull up. Despite orders and why? In view of order dated so and so 16 to 2022, list 20.
Number 25. CA Sanmati.
CI Sanmati issue notice on IA 1 of 21. No, nothing. The 25 issue notice. Next. IA 1 of dispensation is allowed. Requirement for certified copy is dispensed with. IA 1 of 21 is allowed. What about condonation? All right, who appears?
Srihari Gupta.
Yes.
Srihari Gupta.
Oh, let's see.
Number 27, Srimati Nandita D. Haldipur.
My lord, I appear for respondent in this case. My lord, I have no objection for early hearing, but I request your lordship to grant me 2 weeks time to file objection, my lord. Very few days back, I have filed my wakalat.
Wait, mark the presence, learned counsel for respondent praise fund is granted 2 weeks time to enable him to file objections heard on IA 1 of 22 in application for. Why do you want early hearing, madam?
The final order has already been passed.
Oh, heard on IA 1 of 22 after hearing learning counsel for the party in this impact of the case. The aforesaid IA is allowed. Let the petition be listed for hearing on 22nd March.
Very well.
26th March.
Number 28, Srimati Anuradha Agnihotri.
One amendment. You have carried. First, learned counsel for the petitioner submits that they have filed the amended petition. Probably they are ready on this, right? No, you are ready. I mean, what is it? I mean, this is non-carrying for of amendment. Now you are telling that it's not maintainable. He has told us how it is maintainable. Should we decide that question, or should we hear them on admission? Tell us whatever it is. I mean, you are ready. He said that if the order has been passed by the State Commission in violation of Section 14 of the IBC Code. It says IBC Code contains a prohibition that the order could not have been passed. Therefore, the submission is that it is without jurisdiction. If the order is without jurisdiction, the doctrine of availability of alternative remedy doesn't apply. Whirlpool and thereafter number of other decisions. So have you understood?
Council, the order of the State Commission is that amount to be paid after expiry of moratorium period. Now, when the moratorium period is there in terms of Section 14, can that order could have been passed in the light of prohibition in Section 14?
No, I mean, at least you should be clear on facts, right? I mean, as it is disputing, you say that during moratorium period, he says it is concluded. Now you are saying, what is it? Yes, is 7th March. Yes. Asking whether it is incorrect. 3rd March 7th.
The order is on 3rd March 2021. Whether as on that day, moratorium period was there, what happens to the order if that is the case? Expiry of the moratorium period. So when did the moratorium period expire?
We are entertaining this. Yes. Mark the presence in this writ petition. Learned counsel for the petitioner submits that he has filed amended copy of the writ petition. Therefore, the office objection will note in this writ petition, the petitioner inter alia has assessed the value of the order dated 3/3/2021 passed by passed by Karnataka State Human Rights Consumer Commission. Consumer Commission, full stop. Paragraph, learned counsel for the respondent raised an objection to the maintainability of the writ petition. Raised an objection that the writ petition should be dismissed as should not be entertained as the petitioner has an alternative efficacious remedy of filing an appeal under section 51 of the Consumer Protection Act 2019. Huh? Before National Commission under 51, 73. No, this is 2019 only, not amendment, new act. As an alternative remedy of filing an appeal. Don't say section. All right. We are not getting into it. In view of aforesaid submission, learned counsel for the petitioner submits that the moratorium period was in force till 7/6/2021, and the impugned order has been, whereas the impugned order has been passed on 3/3/2021 in violation of section 14 of IBC code, IBC 2016. Insolvency and Bankruptcy Code 2016, and therefore the order is per se without jurisdiction. It is submitted that since the order is per se without jurisdiction, therefore the doctrine of availability of alternative remedy does not apply. In support of our submission, learned counsel for the petitioner has placed reliance on decision of Supreme Court in so and so Whirlpool Corporation, 1998 Volume 2 SCC, 1998 Volume 8 SCC 1, and 2003 Volume 2 SCC page 107. Full stop. Taking into account the fact that the impugned order has been passed in violation of section 14 of the IBC Code 2016, we are, in our considered opinion, the order is per se without jurisdiction. Therefore, it's a fit case where, despite availability of an alternative remedy and in view of law laid down by Supreme Court in Whirlpool, Supra, the writ petition should be entertained. Full stop. Accordingly, objection with regard to maintainability of the writ petition is rejected. Issue notice to respondent. So you are appearing, right? You are on KBA. All of it. Issue notice on behalf of this accepted by Mr. Sohn. The other case also. Same. 89.
My lord, for the respondent, my lord.
What happened?
My lord, in this matter, my lord, the wife has filed the petition, my lord, for a
When is this? Be happy, no? Yes, no lighter when.
My lord, the petition does not survive for.
Really happy. Yes, yes, Mr. Find out.
My lord, the petition does not survive for consideration, my lord, on the ground that the page number 4 of the petition may kindly be seen, my lord. He has refused to join the petitioner, my lord. Even after refusing, they have filed this petition. I'll just read page number 4, my lord. That is the 7th line, my lord. Mr. Gangaraju regarding her husband, and then she came to know about the fact that he was with the third respondent. It is further relevant to submit that the respondent.
Yes. Yes. What is it?
Were found in a room, my lord.
Oh,
and further, he has refused to join the petitioner subsequently. He is not in illegal custody of anybody, my lord. He has gone with the third respondent.
Now we get it. It's a case where your husband is living with someone else. Not in illegal custody. How can anybody? She's a young girl. Obviously, you should understand this. A young girl, aged about 18 years. How she can control your husband? No, but he says right that. obviously, I mean, missing means they must have gone somewhere, right? So many, I mean, places to go in our country. Find out where he will. But what? Yeah, it's so obvious that your husband is residing with someone else. And she is a young girl, aged about 18. How can she control your husband? Please understand. For your satisfaction, he will appear and make a statement that for your satisfaction. Mr. Get him. Get her husband. He will make a statement that he obviously he doesn't want to live with you. What to do?
My lord, already missing
9 or 13 or best course is 13B. Best is 13B. Buying peace of mind. That's called buying peace of mind. All right. This is not a case of habeas corpus, but still not a case of habeas corpus. Yes, Mr.
Please, my lord. My lord, already a missing complaint is already registered, my lord.
I understand.
Please, my lord, I'll file my report.
In notice, 1 and 2 is accepted on behalf of the government by respondent 1 and by so and so. Issue notice to respondent 3. When do you want, Mr.
2 weeks, my lord. I'll file my report, my lord.
Why? Which date? 8th March.
Please, my lord. Please, my lord. Please, my lord.
Emergent notice. 8th March.
Please, my lord.
1 and 2. All right. Yes.
For admissions, number 31, Sri Rupojirao HS.
Live stream. Please. Yes.
Creating a charge under the Karnataka value added tax. Even though the property is mortgaged to the bank.
Let's see. Issue notice.
The stay of this order.
We'll hear you next week. Why do you worry? This is taking notice. Mark this. When do you want to even tell us? Issue notice on behalf of respondent accepted by Mr. Jeevan Medalki, done it. Government advocate. On 3rd of April. 3rd of March. 3rd of March 2022 for consideration of prayer for inclusion. 3rd March.
32, CH Sanmati, Srimati Kalnai Rajkumar.
May it please, my lords, I appear for the SSC, my lords. My lords,
yes.
Could I request for a short adjournment till Friday, my lords?
Friday? That
yes,
means day after.
Day after tomorrow.
Yeah. He is praying for day after Mr. Pardiwal. That's right. Mr. E.I. Sanmati Learned Counsel for the Revenue, Mr. Parshit Pardiwal and Senior Counsel with Mahima Gaur Learned Counsel for assessing. Learned Senior Counsel Correspondent praise for short assessing praise for short adjournment based on Friday's voting. It is 25th.
Obligement.
33, Sri Raghavendra CR, Government Advocate.
Yes. Mr. Raghavendra. Yes. Three to 50. 325, 44. All right, so we will take along with this, right? After given. Similar issue says 44. Okay. All right. So we will take this case. What we are telling you is that we will take up this case along with I-44. Right? You are ready or you want time? But 44, you are already ready, right? Argument is the same, except the fact that senior counsel is appearing. All right. So what are you going to do in 44 if we may ask? So this has to what so he is right. He knows more about you than you yourself. He told us that you are going to seek an adjournment. So next week, what? Huh? Oh, no, but there's nothing. You will see when you hear him that how this precise it is. See, he told you, no, that is only without the question is only of jurisdiction. That's all. So 44, when do you want this to tell us? Yes, Mr. You are ready. So with 3rd of March, you have one case. We have just no, not yours. So 3rd March, fine. So list 33, list along with item list for analogous hearing along with WA number 3250/2018 on 3rd of March 2020. Yes.
There in D group. 34. Ramakrishna, I am government educate.
Abhi, I mean that's fine, but last date also you no.
I informed even the petitioner is hospitalized. So
So when do you want? Next week. What has been done? See, cognizance has bin taken, right? So is it not open for you to raise all objections? No. We are telling you. Please tell him what.
Only cognizance has taken. Regard to your right is concerned, you yourself have stated para 6, 7, 8 of the petition. All the grounds you can urge before the special court.
We will say so. And
we will reserve that liberty. You raise all the defense before the special court.
What instruction? This is what it is. We are telling you. Please go through it. This is nothing. We have also gone through yesterday. What's your name? Please don't. You may take 4 weeks time, but don't pray over and over. This is all what happens. It's a please appreciate and this wastage of our time, your time, and this thing manpower. They are required to type this green sheet. We are required to sign. Then again it goes back to record room again. So please take 6 weeks, whatever 8 weeks, but don't seek an adjournment. Whatever time you want, you take it now. Mr. R. Satish, learned counsel for the petitioner, once again prays for adjournment on the ground that he is unable to seek instruction. He assures this court that he shall not seek any further adjournment and shall positively argue the case on the next date of hearing. Based on whatever, tell us the date of your choice according to you. What is auspicious to you? Whatever. You should not leave us to us. We can fix it tomorrow itself if you leave it to us. So we are asking you, we are giving you the choice. Please tell us. Because you have to argue. Now it's your undertaking. So you know. 22nd March. right? It's on 28th March. But please, I mean, if it comes before this bench, we don't know whether it will come. But it comes, then it won't be adjourned. Yes.
Number 35, MS Rajendra. Malay. Yes, Government Council.
Huh? What is the other? You are unable to get instructions, right? You are in a dilemma from whom to get instructions. Huh? You are, huh? Fine, fine. Yes, huh? You have told us that Madhya Pradesh High Court and some other High Court has stayed. So what has happened there? Nothing. What has happened in? There is a stake that we quite see. I mean, but who is appearing from the other side? They have filed objections. So then you need not seek an adjournment. Huh? Why should you seek an adjournment? Mr. MS Rajendra, learned counsel for the petitioner, none correspondence. From perusal of the record, we find that objections have not been filed on behalf of respondents. Let objections, if any, be filed within a period of 4 weeks. Interim order granted on earlier occasion shall continue to take state of it.
36, CBS Nayak. Vijay Joshi.
I'm for the respondent in this case, Malad.
CBS Nayak.
Malad. Malad, one submission. One submission, Malad. There is connected matter is there on the same common vessel, Malad. So the matter may be connected with that case, Malad. Writ petition 12358 of 21, Malad.
Yes, Mr. What do you want? Yes.
Mala, there is one more connected matter which I have filed, Mala. The matter may be connected with, called with that case, Mala. Writ petition 1.
Just tell the number of the case.
Writ petition 12358 bar 2021, Mala.
That this reputation be heard along with WP 12358 bar 21, which has been filed by respondent. Right? You are respondent in this petition.
Yes, please. I'm for the respondent in this case.
At least for analogous hearing along with WP number 12358 bar 21.
37, CBC Prabhakar.
I appear for the petitioner in this case.
Malad, I am for the respondent.
I appear for the petitioner. Malad, this is a case where the tribunal has interfered with the quantum of punishment, Malad, that is substituting the order of dismissal to that of termination, and in another case, Malad, to that of reinstatement without back wages, Malad. The tribunal held inquiry is fair and proper. Tribunal did not interfere with the order of the disciplinary authority and appellate authority, and tribunal has come to the conclusion that the charges of financial irregularities by the bank employees are proved. In spite of that, Malad, there is an interference with the quantum of punishment, Malad. That is the only consideration, Malad. Whether tribunal could interfere with the quantum of punishment when the bank employee has been dismissed for the proved misconduct of a forging document and a withdrawal of amount from the bank illegally. serious charges are proved, my lord.
What are the charges against it?
Charges, my lord, the remittance, my lord, may file synopsis, my lord. May file brief written synopsis in both the cases in 2 or 3 days, my lord.
No, we can hear you today also, no problem. But whatever choice is yours.
It is better, my lord. I will place written synopsis.
Yes. Learned Counsel to DC Prabhakar, Learned Counsel for the petitioner praise for him granted a week time to enable him to place on record copy of synopsis. This has to be
Much.
So matter number 23. With Anmati, we clearly put the
26. Third on IDS 20. Dispensation dispense with third on IDS 21. Learned Counsel for the petitioner submits that being agreed by the order dated 5/11/2018. Just a minute. 5/11/2018 passed by the income tax appellate tribunal, the appellant has filed a miscellaneous petition under section 254 of the Income Tax Act 1961. It is further submitted that the aforesaid petition was decided on 27/9/2019, and thereafter this appeal has been filed. It is further submitted that the period spent by the appellant in prosecuting the petition under section 254 deserves to be excluded on the principles analogous on the principles contained in section 14 of the Limitation Act 1963. The paragraph we have heard when counsel for the appellant, the application is duly supported by an affidavit. Despite notice, none has appeared on behalf of the respondents even when the matter is taken up in second house. No objection to the aforesaid application has been filed. For the reasons assigned in the aforesaid application, which is duly supported by an affidavit, we find that sufficient cause for condonation delay. Filing the appeal is made out. Accordingly, delay of 368 days in filing the appeal is condoned. IA2 of 21 is allowed. It is all right. That you said no. Which when it was decided that miscellaneous petition, we gave the date 27/9/19. It is also pointed out that against the aforesaid order, an appeal, namely ITA number 160 of 2020 has been filed.
Final hearing number 38.
My lord, I appear for the petitioner, my lord.
Hello, my lord.
Yes. Yes.
My lord, need some. Lordship be posted in the month of March. Lordship, in the month of March for 2 reasons. One, I'll tell you, my lord. The reason is the complaint is registered on 30 of 2007. The new law came from 17th November 2006, and writ petition is already pending and it likely be disposed of this month. So if the entire proceedings may not be valid in law, so that writ petition is also pending in our High Court, number 189 of 2013. We have already moved that matter after your last hearing, my lord. So your lordship may consider 3rd week of March.
3rd week.
3rd week of March. Right.
What's your name, madam? What's your name?
My lord, I'm appearing on behalf of Ms. Sumana Naganand.
Your name, madam?
Anupama, my lord.
Learned Counsel for the petitioner, the Sri Shankar Learned Senior Counsel with Mr. Suante for respond number 1 with who? Respond number 1, learned senior counsel for respond number 1 prays for adjournment. This in 3rd week of March 2022.
39. Srimati Tanmay Rajkumar, Sri K.V. Arvind.
They have told you that they will seek an adjournment. See, they always put you in an awkward situation. He is not appearing. So, very yes, write her name, Mr. K.V. Arvind, learned counsel for the revenue praise for adjournment. Just after, what did we 2 weeks? Just after 1 week.
40, Sri K.V. Arvind, Srimati Tanmay Rajkumar.
Let him come.
41, Srimati Sumana Nagaran.
My lord, I'm appearing for the petition.
My lord, this is also a disciplinary action, the CA Institute. Taken up
yes.
2nd week of March, my lord. There is no
Same 41. Same presence, praise for adjournment. Mr. E also, Mr. Shanti Bhutan also. ASG, learned senior counsel for respond number 1 praise for adjournment. This is 2nd week of March 2020.
42, Sri M. Lava, Sri Jeevan Jain.
Mr. Shankar.
This matter will be taken up tomorrow or day after tomorrow. It can be closed, my lord. My colleague Chandrasekhar, the last occasion I were told it is covered matter. So, your lordship may consider taking it tomorrow or day after tomorrow as convenient.
Day after.
Yes, my lord.
Mr. A. Shankar, learned senior counsel. Mr. Jeevan J. Nirali, learned counsel for the respondent. List. What day after? Friday. 25th February.
Deeply obliged.
43, Srimati Tanmay Rajkumar, Sri K.V. Arvind. 44, 45, Sri Chaitanya Hegde, Sri Nagaraj Damodar. 46, Srimati Sumana Nagaran, Sri K.V. Arvind.
I appear in 46.
Yes.
My lord, I find a memo, my lord, this matter may not survive for consideration. If I may just explain, my lord, kindly peruse my memo of 22nd February.
Have you got it?
The main point, my lord, in this writ appeal is, my lord, the appellant before your lordships, my lord, is an assessee. It had, my lord, a transaction with its parent company, and there was a transfer pricing adjustment, my lord, that was done. During the pendency, my lord, an application was filed for settlement, and that, my lord, that committee under the settlement provision, my lord, passed an order, and tax was paid accordingly.
Yes.
Now, the department, my lord, instituted penalty proceedings under section 271(1)(c).
Yes.
Now, in the writ petition, my lord, our main challenge was that once a settlement is reached under the section 90 of the DTA, that is Income Tax Act section 90, no penalty can be imposed. That was the main contention. And we wanted the section to be clarified or read down accordingly, because penalty would arise on an assessment. Section 90 order is not an assessment. That was the contention. That was not accepted by the learned judge, and the writ petition was disposed of, dismissed actually. Meanwhile, my lord, we had filed an appeal because of the constitutional validity. We had filed the writ petition. We had filed an appeal. The learned judge, my lord, if your lordships could see the order passed by the learned judge, directed that the appellate authority may go into this and record a finding on our appeal. Your lordships will find that, my lord, at
order passed by the tribunal, right?
72. No, order passed by the learned single judge. It's part of the writ appeal papers, volume 1. It's a writ appeal. Volume 1, page 72, my lord.
Yes.
Point number 2 in the operative portion.
Yes.
Appellate authority shall consider the appeal preferred by the petitioner against the order of penalty dated 22/9/15 at annexure S on merits and shall take a decision in accordance with law in an expedited manner. Now, my lord, against this order, an appeal was preferred. The commissioner appeals, my lord, rejected our appeal, and we went up in appeal to the tribunal. The tribunal has now passed an order which I have filed along with the memo.
Your appeal has been allowed.
Yes, my appeal has been allowed by the tribunal on a technical question that the notice issued, my lord, was not in accordance with law. They did not invoke any particular provision. That is following, my lord, the two judgments of your lordship's court. Page 10 of the memo.
Yes.
Now, my lord, so this having been allowed, the main list does not arise, but I only have a request, my lord, that this question may kindly be kept open, my lord.
Yes, yes, yes. Yes, Mr. S.S. Nagan, one senior counsel of the applicant, Mr. K.V. Arvind, learned counsel for respondent 1, 2, 5, and 6. Third, this intra-court appeal has been filed against the order dated 11th of June 2019, passed by learned single judge, by which writ petition preferred by the petitioner has been disposed of. Paragraph. The learned paragraph. Learned single judge by the opposite order has upheld the validity of section 271 within bracket 1 within bracket C of the Income Tax Act 1961 and issued a direction to the appellate authority to decide the appeal preferred by the petitioner against the order dated 22nd September 2015 by which penalty was levied on the petitioner. Full stop. Paragraph. During the pendency of this full stop. In pursuance of the in compliance of the order passed by the learned single judge, not don't in compliance. The appeal preferred by the petitioner was distressed by the Commissioner of Income Tax appeal by an order dated 11/12/2019 against the aforesaid order, the petitioner preferred an appeal before the Income Tax Appellate Tribunal. The Income Tax Appellate Tribunal, by an order dated 3/11/2020, has allowed the appeal preferred by the petitioner. Full stop. On account of the subsequent event which has taken place during the pendency of this appeal, the grievance of the petitioner stands redressed. However, the question with regard to stands redressed. However, the issue with regard to validity of section 271 1C of the Income Tax Act is kept open, which may be agitated in an appropriate case. With the accordingly, the appeal is disposed of. Yes.
Appearing for the appellant, my lords, in serial number 47 and 48. My request for a short accommodation, my lords. There are some subsequent documents that I wanted to bring on records which would be relevant to me. Anytime next week, my lords, I'll file it with a memo and appear physically.
47, 48, place for short accommodation, up to 1 week. A place for short adjournment to enable her to place on record the documents. Just after 1 week. 47 and 48, right?
Please, my lords. Obliged.
49, Sri Venkatesh Sarvati, government advocate.
You are ready, right?
Yes.
Mr. Jeevan, ready. All right. Yes. Please, please. Yes.
On entry of setting machines, which were mounted on vehicles. The issue of that is Whether getting machines which are mounted on vehicles are subject of entry tax or not. There is a judgment on this on the year 94. Same one that it is not taxable. There is a circular issued by the Commissioner of Commercial Taxes saying that if they are mounted on vehicles, it is not taxable. Even the main assessment of aside, but the entry tax was not made. Even the other thing also very against me, I find I have 5 seconds of the there, also against me. I have 5 seconds of the business. I will also against me. I have paid dividend because of factory revenue. That is 20 because. Here it is not 4 5. Proposal notice there is no clarity about whether this machine, mounted on vehicles, that is taxable on 1988, 89, and same proposal note was issued to me. I have replied that matter was closed for the same getting mounted on vehicles. All these are getting in the next case.
What happened?
2009, before the assessment card was passed, 9/11/2009, the assessment card was passed.
9/11?
2009. Before that, 4/11/2009, I have remitted the tax.
4/11?
4/11/2009, I have remitted. The year 2017, 8 years later, year 2017, the issue of the proposition notice, it is 28 weeks of 70, proposal notice, the tax ought to be levied in 2%. Interest ought to be levied in 2%.
No, but what has been done by you have been relegated to an alternative remedy of filing an appeal.
Yes, but there is not by submission for no power to there is no jurisdiction under section 5(2) impose interest.
No, so which provision the interest can be levied?
There is no, they have to review
There is no provision. According to you, there is no provision. So therefore, you say that since the order has been passed without any jurisdiction,
yes.
So therefore, you cannot be relegated to an alternative remedy. That is the proposition.
Yes, that was the.
Yes, what do you say? No. Which provision?
I sought for not personally. In the order, not the officer, the reason personally is not.
Hearing statutory body, Mr. You are not hearing me personally, statutory body. What is this? And one example. No, that's fine. You heard right. He said that there is no provision under the Act to levy interest. Which is the provision? Tell us. If it's not 5B, which other provision? We understand that wrong quoting of provision doesn't matter. But which provision are you levied interest? It's not there, right? That cannot be matter. No, but see, please appreciate if the statute does not empower you to levy interest, you can't do it. Can you? So there has to be. Please tell us and show us any legal proposition. What rate? I will see. Because why your discretion needs to be guided is that there has to be a subject to what you say. Why there has to be a statutory provision to guide your discussion? Because one case you would say 2%, another case you would say 10%, another person comes with a brown hair, you will say 1%. So what? So that's why the discretion, I mean, your discretion needs to be regulated, right? Even subject to what you say. I mean, at the very case law, is there any authority that in the absence?
What is assessed tax? That is only after the assessment of the nation was passed on 9/22/09 and I paid on 4/22/09.
Sir, you argued two propositions, right? Number one is that there's no provision to levy interest under the Act. Secondly, you said no opportunity of hearing, personal hearing has been given. So that's why, so please tell us, is there any decision which says that there has to be a specific provision to levy interest?
This JK interdict constitutional both two propositions, para 16 says there must be for levy of interest
That's what we are saying.
Para 16.
All right.
And going further, para 17
read para 16. Don't be, you are finally arguing the case. Don't be in a hurry. You see the effect of new sitting list, so we are also not in a hurry. So you are the probably only person interested in arguing. So take your time. Don't worry. So para 16.
Para 16 is well known that when statute levies a tax, so by inserting a starting section levies a tax, it is created. Therefore, providing facility for assessment of tax only which is not then point to not occurring. Provision is also made for starting interest on delayed payments, etc. Ordinarily, the starting section itself the liability is strictly the rule of so as to effectuate the object and purpose and not repeat same. But it must also be realized that the provision by the authority is equal to levy direct interest, even if the procedure is forming part of the substantial law. The absence of contract obligation, interest can be levied under law, and it cannot be equal to
Question bench says so. Hey, substantive. No. Please tell us. No, but this constitution bench says so, no, clearly. Forming part of machinery is substantive law for the simple. There has to be a provision. I mean, though not directly saying so, but there has to be a provision. Yeah, there has to be a provision. Unless you are very serious about it, then we will grant you adjournment. If you are very serious and sure about it, that no, even in the absence of, they will grant you time. Otherwise, it appears to be concluded by constitution. This one, other one, this 12th June 2014.
Yes.
Para, let's see, Mr. Jeevan. Para
15, 16, and 20.
15,
15, 16, and 20.
15, 16, 20.
15 not refers to JK synthetics.
All right.
And 16 not.
Yes.
From the aforesaid judgment of the
Yes, Mr. Jeevan. Got the answer, right? First 4 lines from para 16. Huh? Much discuss. No, we will say that all vehemence at your command you are. Yes. You will say so, right? Fine, fine. No, but it can't be. No, it can't be. You should not have issued a notice in the year 2009 anticipating that some provision will come in 2014. Could not have been done, right? What you should do, Mr. Venkatesh, is no, what you should do, apart from preparing a case, you should have given this thing one page. This is what happened. This. It would have been so easy. Now we will have to struggle with facts. All right. Yes, Mr. Venkatesh is the ignorant counsel of the applicant. Given generally additional government arguments or dictates. In this ultra-courtesy, the applicant has received the value of the order dated 27th August 2019 passed by the learned single judge, by which read petition preferred by the preferred by the applicant has been disposed of with the liberty to the petitioner to file an appeal under section 13 of Karnataka Tax on Entry of Goods Act. Karnataka Tax on Entry of Goods Act 1979, herein after referred to as the Act. But giving rise to fighting of this appeal briefly stated up that the appellant, please sit down, appellant which is a statutory body, is inter alia engaged in supply of water and providing sanitation and sewerage disposal facilities in Bangalore metropolitan area. The appellant is a body, statutory body constituted under the Bangalore Water and Sewerage Sanitary Act 1964. If inter alia is engaged, what is it?
Engaged in supply.
It is engaged in supply. A notice dated 21st February 2009 was issued by the Deputy Commissioner of Commercial Taxes to the petitioner on the ground that the petitioner, what have you purchased, Mr.? That the petitioner has purchased jetting, JETTING, jetting machines. Petitioner has purchased jetting machines from outside the state and caused their entry into the local area, which is liable to tax under the Act. It was further stated in the said notice that the appellant has filed, so wherever petitioner appellant, that the appellant has failed to submit the return of turnover in the specified format. You filed the reply, right, to this notice. The petitioner responded to the aforesaid notice by filing a reply. However, and short parcel here. However, the Deputy Commissioner of Commercial Taxes from the demand to stop being agreed, the appellant filed an appeal under section 13 of the Act before the Joint Commissioner of Commercial Taxes, which was dismissed by an order dated 31st of January 2014, paragraph. The appellant thereupon filed appeal before the appeals. Why two appeals? No, you said appeal. No, you before KT only one appeal, right? Yeah, you have. Then it's a typing mistake. The appellant filed. All right. So the appeal filed. The petitioner The appellant thereupon filed an appeal before the Karnataka Appellate Tribunal. Appeals before the Karnataka Appellate Tribunals. The Karnataka Appellate Tribunal, by an order dated 30th/11/2016, dismissed the appeals and affirmed the order passed by the authorities. Thereafter, the Deputy Commissioner of Commercial Taxes passed an order under Section 5B, under Section 5 of the Act, and issued a demand notice dated 18/4/2017. The appellant assailed the aforesaid demand notice as well as the aforesaid order as well as the demand notice in a writ petition. The learned single judge by an order dated 27th August 2019 has relegated the appellant to the alternative remedy. In the aforesaid factual background, this petition has been filed. Paragraph. This appeal has been filed. Learned counsel for the appellant submitted that the Deputy Commissioner of that the learned single judge ought to have appreciated that the order was passed without affording an opportunity of personal hearing to the petitioner. It is further submitted that the that interest. It is further submitted that that the demand notice was that even before an order of assessment was passed on 9/11/2009, the petitioner had remitted the amount of entry tax under protest on 4/11/2009. It is further submitted that that learned single judge ought to have appreciated that the respondents had no authority in law to levy interest, and in the absence of a substantive provision, the interest could not have been levied at the rate of 2%. On the other hand, learned government advocate has learned additional government advocate has supported the order passed by the learned single judge. It is further submitted that in the face of availability of an alternative remedy, the petition should not. The learned single judge has rightly declined to entertain the petition filed by the appellant. It is also urged that no interference is called for with the order of the learned single judge. Paragraph. We have considered the submissions made on both sides and have perused the record. It is right law. It is right law that in a case where the impugned order is per se without jurisdiction, the availability of a writ petition cannot be thrown on the ground of availability of alternative remedy. Petition cannot be thrown on the ground of the petitioner cannot be relegated. Not thrown. Petitioner cannot cannot be relegated to an alternative remedy. Right? The World Code 1998 8 SCC 1. Good talk. In the instant case, the demand of in the instant case, admittedly before an order of assessment was passed, the petitioner had remitted the amount of entry tax on 4/11/2009. Full stop. It is right law. It is well settled in law that it is well settled in law that it is well settled in law that a provision for charging interest is introduced in the statute to compensate for the loss cost to the revenue due to delay in payment of tax. The provision for payment of charging interest can only be on the basis of a statutory provision. C. And so, JK synthetic commercial taxes, as well as the legal bench regime of this court in Yes, we are. Instant case, a paragraph. In the instant case, comma, there is no provision in the act to levy interest. Mr. What? What is it? Eight two. Eight two. If default is made in making payment.
Interest equal to 1.5% of the amount of tax or any other amount due remaining for each month after the expiry of tax is current. In the context of this, the letter wrong provision is removed.
No, that's fine. That's clear. Wrong provision. But this, even levy of interest is not as per this provision. You are demanding at 2%, right?
Earlier,
1/4/2005, it was this thing. Prior to 1/4/2005, it was 2%. With effect from 1/4/2005, it's this thing.
2%.
No. Substituted for the words 2%. 6 1.25% for 2%. That means 2005 1.25%. The grant them liberty.
Even then, only after assessment on this part.
Where is the order of assessment? Fine. So just a minute. It is equally well settled proposition that liability to make payment of tax arises only on assessment to only after an order of assessment is passed, and order of assessment is passed. Paragraph in the instant case. Now this thing. In the instant case, comma. In the instant case, an order of assessment was passed on 9/11/2009, and before passing of the order of assessment on 4/11/2009, the petitioner had remitted the tax. Even otherwise, comma, even assuming that the that interest has been demanded from the petitioner under section 8 within bracket 2 of the act could not 8 of the act, comma, the same could not have been demanded from the petitioner in the facts and circumstances of the case, as there is no order of assessment has been passed against the appellant. Therefore, it is evident that the impugned orders are per se without jurisdiction. However, the aforesaid aspect of the matter has not been appreciated by the learned signatures in the result. Paragraph for the aforementioned reasons, the order dated so and so passed by learned signatures is hereby set aside, and the so and so order dated and demand notice dated so and so is quashed. In the result, execution is allowed. They'll say all right, quashed, liberty is reserved to the respondents to take action in accordance with law if advised. Fine. We don't know. We have granted you liberty. We have granted you the liberty. Think about it, advise properly. Yeah, and no, we have reserved the liberty, right? We don't know. What to do? Please. No, but what to do? Please tell us what to do. No, but see, this proposition, Mr. Given, you can't dispute that the liability to pay interest on the amount due will arise when there is an existing order of assessment. Where is the order of assessment? No, but yes, no, that is under protest. Please, he said so. It is under protest, right? Please wait. No, but he told us unless he is, unless he is factually wrong, we can't say. But he told us that there is no assessment and he has deposited the amount under protest. Please verify. No, please verify. If you say so, we will hear you again. There is no problem. Mr. What? Tax, there should be no dispute. No, but what is the pointing out?
Returns are filed. There I have not stated about betting machines. Only as an issue of proposition. I have paid the sum of 4 and I have stated that
Please see para. What para? That's why you understand now the importance of synopsis. Why? Yes. No. Wait. Don't run. Still he has doubts. Yeah. All right. If you want, we will take it up day after tomorrow. There's no hurry. Yeah. This matter. You type this. Keep it with you day after tomorrow. Pray for learned additional government advocate, pray for adjournment. Yes, and you please give us a synopsis. What all you know, what you have not stated in the return, all that, annexing a copy of the return, everything should be clear. Yes. Yes, please.
15, the Hare Kumar case, government advocate.
We have time. How much time will you take? Oh, yes, Mr. You are ready. He is ready. What you have challenged? What? So have you prepared a synopsis? No. Please. Next week, anytime. Learned counsel for the petitioner prays for a short accommodation. Appellant prays for a short accommodation. Short accommodation to enable him to produce a copy of the synopsis. Let's next week. Please give us synopsis, Mr.
51, Basura Gudachi, the S.Y. Kumbar. 52, the Ramesh K.R. Government advocate. Anantapati Harigoda.
What subsequent events?
No. See, the scope of this writ petition is confined to examining the validity of the order passed by the special court. Right? It turns upon subsequent events. The order stands as it was passed. We have to examine whether it was rightly passed or not. Nothing. What subsequent? Last date also it was adjusted. Not turn by turn that next time he will seek an adjournment. Then you will say he thought, now my turn. It can't happen. See, it's an order passed by the special court. What is the order? See, what is there? Yes.
Then some villages started with the revenue stating that lands are not rents. But in that, without any resistance, the particular vendor had quite a civil judge. For declaration and title against the state. Then since it was related to government and the land was the this took for the year 2010 the group was manual when the matter of process for argument special. But when the matter was brought to the special court,
It is applying this case. How is to get the land grabbing action? Down here. Yes. No, just like we are just having a look at the provision for transfer. Transfer of proceeding, right? Case is pending. Constitution of a special court. When was the special court constituted? Mr. Could have been transferred. Fine. Yes.
I instructed the petitioner to verify whether the land is exactly available in the public. Then we had approached the Tahsildar, and Tahsildar had issued the grant certificate for the grant inspection. Where it is protected that the land was granted instead of petitioner. Petitioner arrested except the grant inspection at the particular.
Was the original prayer of the suit?
Then when the transfer to the special court, I amended the prayer with the prayer
adverse possession.
Then after amending the claim for adverse possession, this document was there. Again, I filed an application to remove that adverse possession.
You could have sought the relief in the alternative, right? Instead of seeking deletion. You could have sought the relief in the alternative, right? So I be declared as this thing, I have a title and it be declared so. Alternatively, adverse position. No.
The prayer for declaration, that's all.
Position. Like whatever way to applying this is the amount to taking as a taking. Allowed in the
By producing the
as it is, there must be state 2019 spending we decided today. Fine. Yes, this defines what. Yes. So let it be decided once for all. We understand back end of the trial. But what is the prejudice? After all, it's a public document on which he is placing reliance, right? The authenticity of the document is beyond any shadow of doubt. It is necessitated because those facts were not within his knowledge when he scripted the proceedings. So now it has surfaced all of them. What is there? Let it be decided. No, this issue also should be decided here only, once for all. 2019, this petition is pending. There has to be a stay, right? There is a stay. See, by now it would have been decided. What's there? You will have the, what is the prejudice? You will have the right to have this thing. This thing, consequential amendment in your pleadings, right? That's it. Right? What nature? See, it is based on taking a hyper-technical view. You may be correct, Mr. But the fact is that it's a public. His now claim is based on a public document, and its authenticity is beyond any shadow of doubt. That's why we are convinced to, take a view in favor of the petition. Otherwise, some entry here and there which could have been forced. It's a public document, right? You cannot prima facie dispel. You cannot say that it's not genuine, right? It's an order of grant. Let him prove it. He will have to prove his title.
Seeking. No, he's not withdrawing it.
No, they see. Hey, Mr. You should tell us this.
Page 47. Page 47.
Belief is by.
That's the amendment application, no? Page 47. That's the. See, what's the second para 3? Read that. You said you are seeking withdrawal of prayer for adverse possession, but you read that. Read that.
The word after the words declaring that the painter of perfect
be removed.
to declare, not to be removed. I'm trying to withdraw that.
You're withdrawing it to remove it.
Since there is a document prayer for the person.
Thank you. No, what is now tell us why were you seeking an adjournment? What for? How does in this petition you have challenged the order rejecting the application for amendment? Subsequent events, how do they make any impact on this? How you place our order there? Thank you. Number 53. The Krishna SD. Yeah. Yes. Yes. Why? Why it is held to be not maintainable? Maintainable, right? What is the reason assigned by the land grabbing court? Please tell us that. Prima facie, it appears to us that it's maintainable. Against the true owner is maintainable, right? Even if government is the owner. This is the reason. Incorrect. Karnataka High Court. All right. Yes. Yes, Mr. Comment Advocate, what do you think? So Mr. Suit for injunction has been dismissed on the ground that the land is government land. So it's maintainable, right? Supposing it is in possession of a government land, you cannot throw him forcibly. You have to take recourse to the procedure in accordance with law. 68 Supreme Court 620. And the special court dismisses because you are the owner, he has no right, and therefore it has been dismissed. He's saying not even given opportunity to adduce evidence. Fine. Yes. Yes, madam, right. Yes. Order sheet you record. Then in this petition, in this writ petition under Article 226 of the Constitution of India, the petitioner has asserted the value of the order dated 23rd November 2018, passed by the Special Court Karnataka Land Grabbing Prohibition Bangalore under the provisions of Karnataka Land Grabbing Prohibition Act 2011, herein after referred to the Act, by which the suit for injunction filed by the petitioner against the respondents has been dismissed on the ground that the same is not maintainable. Paragraph fact giving rise to filing of this petition briefly stated are that father-in-law of the petitioner, namely Sri Kailash, was in possession and occupation of the building situated on survey number 195/1 at Mekur, Hoskeri village, so and so of Virajpet Taluk, Kotgu district. Full stop. It is the case of the petitioner that the predecessory tax of the petitioner were in possession of the property dispute since past 100 years, past more than 100 years. Full stop. It is the case of the petitioners that the respondents made efforts to demolish the property of which the petitioner was in possession. Full stop. Thereupon, the petitioner filed a suit seeking the relief of permanent injunction before the court of before Civil Junior Division, Virajpet, Kotgu district. Full stop. The paragraph. The respondents, on being served with the summons of the suit, filed the written statement. On the basis of the pleadings of the parties, the court framed the issues. Full stop. However, during the pendency of the suit, the Act was enacted, which came into force with effect from Karnataka Land Grabbing, which came into force, which came into force in the 14th, which came into force on 20th October 2014. Full stop. The trial court therefore in exercise of powers under section 20 of the Act, transferred the civil suit before the land grabbing court, whatever special court mentioned, right? The special court heard the argument on the question of maintainability of the suit and inter alia held that since the suit property since the scheduled property belongs to the state government, therefore the plaintiff, the petitioner cannot maintain the suit for possession as her possession in respect of the scheduled property is not legal. In the aforesaid factual background, this petition has been filed. Learned counsel for the petitioner, Mr. Trust 68 Supreme Court 620. AIR 68 Supreme Court. Learned counsel for the petitioner submitted that the petitioner as well as her predecessor in title were in possession of the property for a period of more than 100 years, and therefore they have acquired the title. It is further submitted that whether or not the petitioner had acquired the title could not have been decided without recording the evidence, as it was a mixed question of law and fact, and on the aforesaid preliminary issue, the suit could not have been dismissed as not maintainable. On the other hand, learned government advocate, Mr. Jeevan J. Nehral, right his name. On the other hand, learned not naming the order in the order sheet. Yeah, on the other hand, the additional government advocate submitted that the respondents are the owners of the property and the plaintiff has no right, title, or interest in respect of the property. Submissions made on both sides and have perused the record. Admittedly, full stop. In the instant case, on the basis of pleadings of the parties, the trial court had framed issues. Thereafter, the matter was transferred to the land grabbing court. Full stop. The issue whether or not the plaintiff has acquired title in respect of the suit property by adverse possession is a mixed question of law and fact, which could not have been adjudicated by the trial court without recording the evidence. Full stop. In any case, even if the plaintiff may not have title in respect of the property, yet even if defendants may be the owner of the property in question, they cannot be permitted to forcibly dispossess the petitioner as law does not permit forcible disposition. See, so AIR 68 Supreme Court 620. The impugned order, therefore, in any case suffers from procedural irregularity as well as the error apparent on the face of the record. It is therefore quashed and set aside. The special court so and so is directed to record the evidence of the parties on the issues framed by the trial court, and thereafter proceed to decide the suit. Proceed to decide the suit on merits, including the question with regard to maintainability of the suit. Accordingly, the petition is disposed of. Quashed and set aside. We have said both. Not both. We have directed same thing. Set aside. Rather, correct. 54, government advocate, Sandeep Wilbur. Oh. Oh, this is a judgment. All right, after 2 weeks. All right. This is even related to government advocates. Sandeep, he was learned counsel correspondent, learned counsel for the learned additional government advocate raised for adjournment to enable him to prepare the case and argue the same list after 2 weeks. That's all right. Fine.
Let's for Mr. Somshekhar Millards for the appellate university case of a workman who came to be discharged from service.
The counsel for respondent is not there, Mr. Murthy. Counsel for respondent is not there. It's Chetan B.
The respondent counsel is not present before the court here.
You can pass it over or.
Let's, Lordship, but I think afternoon there is no sitting, as I understand.
Afternoon, no sitting. No sitting. You are right.
Your Lordship may have it after 2 weeks, my lord. Let him come. I find it very difficult to see that by and large he remains away from these proceedings. But nevertheless, I will not insist on the hearing.
Mr. Our predicament is we are ready to decide. We have an hour at our disposal. But the problem is, if we decide it one way or the other, and if supposing if he loses, he will file an application for recall on the ground that the order has been passed in violation of principles of
Yes, my lord, yes.
Violation of this is the first ground, which I have come across here only. I would rather passes order in violation of natural justice.
I would rather wait for 2 weeks before he says that.
Yes. Mr. Murthy, learned senior counsel for the petitioner, none for respondent. Awaiting appearance of learned counsel for respondent, hearing of the petition is deferred, list after 2 weeks.
Obliged.
Pass over matter, Simba Party, Sri K.V. Arvind, Srimati Tanmay Rajkumar.
What did he? Yes. Where is he? Mr. Arvind. Yes, madam. Correct. None for the applicant even when the matter is called in second round. Write her name, Ms. Mahima for learned counsel for assessing, awaiting appearance of learned counsel for the revenue hearing of the petition. Appeal is deferred this next week.
43. Sri Tanmay Rajkumar, Sri K.V. Arvind.
Same order next week. Oh, no, you are there, right? So none for respondent in this case. Right, next week, madam. All right. Also, see, this Mahima got learned counsel for the assessee, none for revenue. Learned counsel for the assessee submits that the matters be approved by an outstation counsel. She therefore prays for adjournment list on 17th March 2020.
45. Sri Chaitanya Hegde, Sri Nagaraj Damodar.
So, effect, this is given of the sitting list being published in advance, right? That's it, no? Change. Okay. Transition. And others who have to come here, they are mentally preparing for migrating to our court. Okay. None for parties, even when the matter is called in second round, awaiting appearance, hearing of the petition is deferred, make clear no appearance made, appropriate order shall be passed. This after 1 week.
51. Sri Basavaraj Godachi, Sri S.Y. Kumbar, Sri S.K. Shivshankar.
None. After 1 week. Which one?
It was not this time. Yesterday they have moved on matter. That was not. That's why.
Yes. Yes. What is it? Which page? No, what you are entitled to be considered for admission to PG course. PG. Take quota.
Only that certificate was not available. Therefore, she was considered in the first block, not brought under the Karnataka quota, but brought under the Karnataka quota. The second government is still not coming. So I have got the certificate, but I have placed it before them, but I am going to request let them consider. In fact, I produced it earlier, but before that, they refused to take it. They said the time is already over. But they have started extension of time for online submissions. But I showed for offline submissions.
Right. Yes. We are the council for the petitioner. Third on the question of admission. To notice on behalf of respondents number 1 and 4 is accepted by what is government? Yeah. No. Is government that AGA. 1 and 4. AGA. 2 and 3 is notice on behalf of respondent number 2 and 3 is accepted by Mr. N.K. Ramesh. This is directed to reflect the names of council correspondents in the court list. Learned counsel for respondents number full stop. Learned counsel for the line below. Learned counsel for the petitioner submits that the petitioner has completed her education in the state of Karnataka. It is further submitted that petitioner is entitled for consideration for admission to PG course, postgraduate course, right? Postgraduate course under the state quota. However, at the time of first, in first round of counseling, the petitioner was unable to produce her mark sheet what certificate? Study certificate. A study certificate from class 1 to 3, as the same were misplaced. Therefore, in the first round of counseling, the petitioner was considered for admission to PG course against the seat other than state quota. Full stop. Paragraph. It is further submitted that aforesaid documents are now available and petitioner is ready and willing to produce the same before the Karnataka examination authority, and her candidature be directed to be considered in the for admission to PG course in second round of counseling under the state quota, right? Paragraph. In view of a submission, learned counsel for respondents number 2 and 3 prays for a short accommodation to enable him to seek instructions. List on Friday. List on 25th May, February 2020.